Hello, welcome to our weekly webinar, and today is going to be totally Q&A. We're going to have 1 hour where we're going to try to answer all your questions, and for right now I'm just looking to see as the people start joining, and so we're going to give it a few minutes to make sure that everyone's gotten a chance to log in to the webinar. I hope you all are doing well, had a good weekend, restful, excited about perhaps getting your adjustment filed. And like I said, we'll give it just a few seconds. When the numbers start, when the attendee numbers slow down, that's when I typically will get started with the discussion. And see who we all have. And we're waiting for our moderator to get on. And then we'll get started with the Q&A to make sure we can answer all the questions you guys probably have. For those of you who are joining us for the first time, welcome. For those of you who have been attending our weekly webinars every week, welcome back. And I know that some of you have joined our Telegram group. We're going to be having other Telegram groups shortly for like E3s and investor processes like the L1, EB5 for those that may be interested. Today what we're going to do is, like I said, just go through a Q&A. I wanted to take do some of the standard administrative stuff first. Our weekly webinars are every Wednesday at 12 o'clock. That's not the only way to connect with us. You can connect with us on our various social media platforms where we use different forms of medium to effectively communicate to you, whether it's Twitter, Facebook, Instagram, YouTube, LinkedIn. Hey, how are you? Okay, our moderator is here. And Telegram. And then we've got resources, a chock full of resources from our previous webinars, everything from RFEs, and if you've not started your perm process or think about starting another perm process, you know, what are the critical things for the perm? All these resources are online, so please subscribe to our YouTube channel and comment. You know, we respond to the comments and questions. I'd love to hear from you. I love connecting in that way. That's why I really enjoyed the Telegram so much, although nowadays we're kind of busy with trying to make sure our clients' petitions are filed, and my role really in that is reviewing the processes and, you know, trying to make sure that we have some redundancies in place so that all the petitions are getting like a 2-attorney review. So coordinating that, I haven't been as active on Telegram as I have. But let me know what you want to hear about next week. We would, you know, usually it's through questions that we receive that we put forth the agenda. But if there's something very specific next week that you'd like us to talk about, we're happy to do that. And if you don't know, our Cella Chats forum is on Telegram, and here's the invitation. Join the forum because after this week I'll be back on, because there's, you know, immigration, there's still tons to talk about, even after the adjustment pull, which is, you know, the new H-1B rules. There'll be a lot of changes to that, the challenges, how to get that through and plan out, you know, your travel and other things as this is coming up. So luckily, you know, there's always something to talk about within immigration. Hopefully in 2021, we'll be talking about some positive changes that are coming up. So connect with us, share the Telegram link with your friends, because the more people we have, the more effective diverse discussion we can have. And like I said, again, connect with us on social media and view our previous recordings that may be helpful. And if you've got any questions that you didn't get a chance to answer today, then please email us at info@chelolaw.com. Again, it's info@chelolaw.com, and I'm sure Kara will send the links to Telegram and also the chelolaw.com email through the chat mechanism to all the attendees. So without any further ado, let's go ahead and get started with the questions.
All right. Afternoon, everybody. Before we get serious business and, with your attorney answering all your questions, I always feel like there's a lot of tension around everywhere. I just lighten up. What I say is, your applications will be taken care of by your attorney, and she and her team will do a great job. So two things. One is to lighten up. Well, most of you out there, I'm sure, are cricket-loving fans. So, the IPL is going strong. I don't know who you are supporting. I'm from Andhra, so I support the Sunrisers. They're not doing that great. Hopefully, they will turn it around. Today, Bangalore is playing with Calcutta, and they're doing very well. So hopefully, Bangalore people out there will have something to celebrate. We'll be in playoffs. The other important thing, as you know, in 2 weeks is the big election in the United States of America. I know some of you may not be eligible to vote there, but there's something you can do actually to make it happen, make a 100% participation, is to reach out to 3 of your friends who you think, who you know are US citizens, right? And have them, make sure that they and their families go to the polling booth and vote. Early voting has already started all over the country, and including here in Richmond and in the greater metro area. So I encourage you to reach 3 people, 3 US citizens that you know, and have them reach and go to the polling and vote, and let those 3 people reach another 3 people and let them request, go to the polling booth and, vote. This 3 times 3 times 3, I'm sure you know where that is coming from. I borrowed the idea from megastar Chiranjeevi's movie, Stalin, right? So, Chiranjeevi, Zindabad. All right, on that note, that's all from now. I'll give you some more lightning stuff later on, but if you need it, I just thought I want to open that. And let's go to Karthik Mehta. If priority date not current as per filing date, would you recommend filing I-140 new application for downgrade from EB2 to EB3?
So if your EB2 is not eligible for dates of filing, and I've said this before, the biggest benefit of filing this month is the fact that you get your adjustment in place. And we have stated in our previous webinar what the benefits and what the risks are in whether you amend or downgrade and file a new petition. And I think that whatever issues people have had with the previous petitions may have been because they weren't submitted correctly, but filing a new petition should not be a problem. It is actually within the USCIS tips and instructions. So, it's not, we're actually attaching that to our new petitions that we filed to say, hey, it's on your, this is what you said we could do, and that's what we're doing to make sure that it doesn't get rejected.
All right, I like to make a announcement and a request to please do not post your questions in the chat box. All right, so please put your questions on the Q&A box. I got a couple of people have posted in the chat box. I will take it now, but you don't have to post it on the Q&A again, because there'll be some confusion, right? So I'll take your questions, the 2 folks who have put it on the chat box, but the rest of us, please, if you could appreciate putting it on the Q&A box. All right, Let's go to Revati Patil. Have you used alternate source for LCA filing? If yes, can you provide more information on that?
Oh, you mean for an H-1B? Yes, you can. You have to be really careful. The regulations outline what type of alternate wage sources are eligible. So the question, for those of you who may not understand what she's saying, the LCA, you can either use the wage source that's outlined by the Department of Labor, or you can use an alternative wage source as long as it meets the criteria. Many, many years ago, Watson Wyatt was one of them, because the wage has to be geographically specific. There has to be a certain way it's calculated. So you can use it to answer your question, but you have to be careful as to ensuring that it complies with the regulations.
Okay. We're going to go to Pradeep Koganti. Both I and my spouse have EB2 140 with priority dates January 2014 and October 2014. We have filed a new EB3 petition for my spouse. Would it be a good idea for me to file I-824 to change my EB2 140 for consular process, considering potential EB2 advancement and delay in I-485 adjudication? In this case, can I still use EB3, EAD, and AP from my spouse petition with me as a derivative?
You know, there's a lot of confusion about this. There are a lot of people that have asked me. I heard that if you file an EB3 downgrade, that if you use the employment authorization and advanced parole is associated with that, that somehow hinders your ability to file another I-140 petition. That is incorrect. The issue about using the EAD that's critical is as it's related to your H-1B. Because if you use an EAD for an employer that is not your H-1B employer, you have violated your H-1B status, and therefore you no longer have that non-immigrant status. But that does not affect your ability. So you can use the EAD. Let's say you are working for your H-1B employer. You can still use the EAD. That's okay. You just can't use it for somebody who's not your H-1B employer. Now, you filed an adjustment pursuant to your wife's I-140, downgrading it to an EB3. You have an EB2 that's pending. If it advances, you can go ahead and file another adjustment pursuant to that I-140 that you have. And I know that people say, oh, my attorney said we can't file. The regulations state that the USCIS will only adjust you on one, okay? Doesn't say that you can't file multiple. They will eventually say, hey, you've got two pending, you got to choose one. So when your EB2 advances, you can file another adjustment pursuant to the EB2. You don't have to do consular processing.
All right. Nilesh Kulkarni is asking, what is the expectation for EB2 date movement? Will it go back?
We don't know. We're all just with bated breath waiting for the visa bulletin to be published. I knew that it would be late this month. So we just have to wait and see. I mean, it just depends on how many applications they've reached so far and how many they predict that they may get by the end of the month. So unfortunately, I think all the people that are predicting it, we know that EB3, because so many people are filing downgrades, is probably going to be impacted. We don't know how EB2 is, because the calculation takes into account not only the individuals, but how many dependents. So.
Right. Let's look at Anil Kumar, and his question is, could you please clarify which option would be better for EB2 to EB3 downgrade? Filing the downgrade as an amendment to existing EB2 or file a new I-140 in EB3?
We had posted, last week's webinar, we spent a great deal of time talking about that. If you are not part of our Telegram group, I suggest you join it, because we've put together kind of a notice for all our clients to sign that says, here are the risks between EB2 filing, downgrading from an amendment versus a new petition. And I'm going to be sharing it with the Telegram group today. So, if you haven't joined, join that, because that'll kind of outline what the risks are. And if you get a chance, just listen to our webinar last week, because I went into it in great detail and giving the sources. I think, you can file either way, but you have to look at the totality of the circumstances to determine what would work best for you. But I don't believe that there is as much of a risk in filing a new petition as a lot of people have alarmed. And you'll see why when you look at the webinar.
Okay. Next question is from anonymous attendee. My wife and I are on H-1B and both have approved EB2 I140 with different PDs. I'm downgrading my EB2 I140 and added my wife as a derivative. Assuming we have our EADs approved and use them, and in the meantime, EB2 dates move forward, and my wife's PD becomes current in EB2, then can she file 485 adding me as a derivative? Could you let me know if we could do it without issues and complications?
Yeah, you can. And what typically you will do is when you file the EB2 and you get the receipt notices and everything else, you may want to withdraw your previous EB3. At some point, USCIS is going to say, hey, you got to choose. You can't adjust on two different applications. But what you can do is you can withdraw the previous EB3 if that were the case. And yes, you can file an adjustment and have your wife and file as a derivative.
All right, sounds good. JM Money is asking, example, they have 12/1/2014 instead of 14/1/2014, which is the actual date. I left my previous employer on 11/1/2014, Friday, and joined the current company on 14/1/2014, Monday. Can my lawyer fix it now? Will it impact my I-485?
Was it incorrect on your perm? Where is it that it's, I don't understand where it was incorrect. If it was incorrect on the I-9 form that your employer put together, that's not submitted. So that wouldn't be an issue, but I don't see where it would be on any of your immigration documents.
Okay. JM Money, if you are not satisfied, just send an email to info@chalalaw.com with a little more details. As Lakshmi is asking which form and where, and she will respond with great detail. Next is from another anonymous attendee. Has two questions. Question one: as I'm downgrading from EB2 to EB3 with filing new I-140, what should be answered for below question in I-140 form? I answered as no. Question number 10. If you're filing this petition without an original labor certification, are you requesting the USCIS request a duplicate labor certification from the Department of Labor?
Right.
So no.
So first of all, I don't know if you're filing amended or new, but regardless, if you're filing a downgrade, any downgrade, you don't have the labor certification with this filing. Usually when you file an I-140, you have your labor cert, the original. Because you will not in this situation, you would have to say, and it scares me to death that you are filling out your own form, but you have to request the USCIS to get a copy from the DOL.
Okay. Second question: as I'm hearing the USCIS are rejecting forms filled as new instead of amendment when downgrading. What should I include to make sure USCIS don't reject when filing as new I-140?
Yeah, you just have to make it very clear on the cover letter, your attorney does, to make sure that they understand that they have this benefit. All the things that I've outlined earlier as to why it's permissible. And the forms have got to be completed correctly. For some of the people that have been getting rejected, it's because they didn't do that their petition was rejected, but if you undertake that, then there shouldn't be any problem.
I think this gentleman here, when he asked that previous question about the dates, so he probably forgot the qualification. So his qualification was, my current employment date on my perm is off by 2 days. 2 days early, they have Saturday, but my joining date is Monday. Don't I have to worry about it during my I-145?
Probably not. If they raise the question, there's a strategy involved. Do you address it proactively and just alert the USCIS that there was some sort of typo? I would wait to address it on an RFE, and I'll tell you why. It very well, it's going to take 7 to 8 to 9 months for them to adjudicate these I-140s, if not longer. By that time, we could have a new president, a new administration, a new USCIS. So this current USCIS immigration friendly, so I would respond to it on an RFE if it's brought up.
Okay. Lakshmi, are you still there?
Mm-hmm.
Okay. I had a few, couldn't hear you for some time. There was some, disturbance. Next question is from Prakash Pavaluri. I changed from employer 1 to employer 2, and I-797 is valid until July 2021, whereas my dependent's I-94 is valid until May 2020, and filed H-4 extensions with employer 2. They have done biometrics and waiting for approval. Will they go out of status if the results not come within 240 days?
The 240-day rule is an I-9 rule, and the 240-day rule only applies if you are the primary. If you're an H-1B and you file a timely extension, you are permitted to work because I-9 dictates your work authorization for 240 days. That's separate. When you file a timely extension, while the extension is pending, you are not in a specific status, but you're in a status authorized, an authorized status. And we have a webinar that just talks about the difference between a specific status and a status authorized. The reason why that's important is because during that period, they don't accrue unlawful presence. And so there is an authorized status that they have, so you don't have to worry about that. And the 240-day rule doesn't apply. Even if you're an H-1B and your extension is pending, you are authorized to work 240 days while it's pending. After the 240 days, you're not authorized to work, but you don't have to depart the United States. You're still in a state authorized by the Attorney General. So they're two different issues.
Ladies and gentlemen, I would like to sincerely request to please put your question on the Q&A box and not on the chat, please, so that I can give complete attention to your questions in a timely manner. Okay, let's go to the next person. Anonymous attendees. Regarding the Form I-944 liabilities, if we bought a house 400K last year, do we have to put the monthly mortgage or the total loan amount? And if the value appreciated a bit, can we use this current value as the asset?
You all are really worrying about the I-944 a lot more than you need to. If you've got a job that's paying a good salary and you haven't got on food stamps or vouchers, that's really what they're looking for. I would answer the form in exactly in the format of the questions that are provided, and I wouldn't worry too much about trying to put down the new evaluation of the home. They're not going to care.
Okay. Let's go to the next one. Vaishnavi Chepiala. My wife and me have an emergency and have to leave the country. We are going to submit our paperwork early next week for filing. If we receive the receipt in 3 to 4 weeks, what are the steps that follow? How long does it take for downgrading from EB2 to EB3? Both our H1 and H4 need stamping to return back to the country, so we are hoping to get the advance parole to return back. After receiving the receipts, do I have to wait for the downgrading to be completed, or can I ask for expediting the AP immediately? Or does the advance parole process start only after the downgrading? Thank you.
A couple of things. Number one, if you leave the country while your AP is pending, the USCIS will deem it abandoned, so they won't adjudicate it. So don't worry about your AP. That's not going to be the mechanism by which you return to the country. What you can do is, if your visas have expired less than 24 months, you could probably leverage the Dropbox option, so you don't have to go to a visa interview. So you can get your H-1B visa stamped through Dropbox.
Okay. There was a message from Shilpa G. Says, greeting Chala. After that, I didn't see anything, but maybe the following question may belong to her. Processing or filing question. In Form I-140, is it all that attorney need to check the option to amend a previously filed petition, in quotes, and give previously approved I-140 number or downgrade EB to EB3, or anything else to be done?
They have to do that, and then they have to request they have to tell the USCIS to ask DOL for your previous labor cert, because it's filed without a labor cert.
All right, Harish K is back and says, he's asking, how can I find out from the I-140 form whether my application has been filed as new or amended, other than the checkbox on Part 4? What are the answers for question 9 and 10? My attorney is using I-140 form which expired on 5/31/2020. Does this work?
Yeah, I think there was we had posted something about some of the forms that are new forms, because remember there were a series of, there was a court case that enjoined the fee increase, and there were some forms associated with the fee increase. There's some forms that have been upgraded that are not associated with the fee increase. And so those are the forms that need to be used. And if Kara is listening, she can kind of post on the chat what form we're currently using. I don't remember, because I review them, but I've got other attorneys that are looking into that. And that is, how you would determine whether it's amended or it's a new petition. By checking amend, it would be an amended petition.
Okay. Let's go to the next person. Mokshera Thapa. In order to file LCA for universities, what if there is not enough data from CUPA-HR? What other options we have for teaching faculties? The relevant SOC code is engineering teachers post-secondary.
There is a specific wage survey for university professors. So, if that wage survey doesn't work, a lot of the universities will belong to various organizations that may have their own wage survey. So that could be one of the ways in which you would do it. The bottom line is it's got to comply with the regulations, and it's tough. I get it, especially now with all the changes, but there are a bunch of wage surveys out there that do comply with the regulations, where you can probably get a better a better, more realistic wage, but you would have to, most of the time you have to pay for those services.
Okay. Got Shilpa G back. I think our question follow a little later on. I really appreciate you providing us with the valuable information. My question is due to my visa rejection in the past. My credit history is not that great and I have had a charge off in the past. So I am wondering how this will be interpreted or affect my GC with my I-944 form.
Like I said, as long as you're being paid a good wage, the fact that you don't have money in your bank account and you don't, have a lot of savings, the fact that, your credit history may be a little suspect, those are not things that I would really worry about. And remember, by the time this is getting adjudicated, we're going to have a new hopefully, fingers crossed. I think what Shaker said is correct. It's, if you can give your friends that are U.S. citizens rides, so they can make sure that they go out and vote. Because some people, especially the elderly community, may not feel comfortable in driving. So, that would be a way in which you can get out the vote. But if we have a new administration, all of this would be for naught. But assuming that we don't, the main purpose of the I-944 is just, it's a way in which they can see if you're not a charge now, will you become a charge? So I think most of you would not have an issue with that at all.
Yes, if any of you in the Richmond metro area want me to give a ride to somebody for the polling booth, let me know. I'll have a taxi service free. Again, some of you are putting questions on the chat. Please put your questions in the Q&A box, please. Bhim Rathore is asking, we have to file H-1B amendment to add an additional location for my work. Do company have to pay revised salary for existing location, which is already in approved H-1B, which was approved recently for 3 years?
No, well, if you're amending it for a new location, any amendment would be subject to the new salary wages. Now, remember, not all change of locations require an amended petition. I think we have one of our webinars that talked about, there's something called paraplectic work sites. There is something else where you're only at that work site for a certain period, there's a certain number of days and so forth. There's also, when you're changing within the same MSA, you're not required to file an amended petition. It is also when you are changing within commutable distance, you're not required to file an amended petition. But if you don't fall under any of these exceptions and you have to file an amended petition, then yes, the new location would be subject to the new wage. Your previous location would not.
All right. Venkat Kanikaram is asking, after we have submitted the 485 EAD application, we can collect the EAD after 90 days of submission from local office. If we don't receive it in the first 90 days, is the 90-day count start from date of 485 application submission or from the date of receipt?
They're no longer honoring that. For those of you who don't know, previously, when you filed for an I-765, the USCIS had 90 days to adjudicate it. In 2014, when they allowed certain I-765s, not all of them, just certain, to continue working even while the petition was, while your EAD expired, they did away with that whole 90-day rule. So you can no longer request an EAD at your local office if it's been pending for 90 days.
All right, here's our friend, Abir Singhal. Abir, how are you, man? Let me know if congratulations are in order. This question is, has there been a change to minimum wage that must be paid to an EB1 applicant executive?
No. They just want to make sure that it makes sense, so, but there's no, and And the wage can be paid by the parent entity. It doesn't have to be paid by the US entity.
All right, Avi, let's toast for that. Next one, anonymous attendee. I have Ev3 I140 with PD January 2014. So planning to downgrade. Would like to know if this is correct. Filing 485 with amending and filing new I-140.
Can you say that again?
Yes, this
he's got a
person has a Ev3 I140 with priority date of January 2014. He wants to downgrade. And he wants to know if filing 485 with amending and filing new, or maybe he wants to say amending or filing new I-140.
Okay, like I said previously, if you, because it's not that I don't want to answer your question, it's a very, it's a long explanation. There are risks and benefits to both. So what I would suggest that you do is either listen to our YouTube video from last week, where I go through that and outline what the risks and benefits are if it's approved under amended, if it's approved under new, if it's denied, you know, all those things. So take a look at that. And if you're not part of our Telegram group, then join that, because we'll be posting some information on that as well.
Okay. Next question is Kranti Viranki. In a EVC model, I was working for client A in X location, and I got my H-1B approved with client A location and my home address. Sure, I think maybe it got cut. I'll catch up with that question because I don't see the rest of the question. Anonymous attendee, the next one is, I am in 60-day grace period. My OAS has been filed with my spouse's 485. Between the time we file OAS and by the time we receive the receipt notice for 485 AOAS, is there a way to demonstrate my legal status in this duration?
Yeah. You know, I would take a couple of things with you. Number one, you want to document your last date so you have a clear idea of what that 60-day window is. Number two, you want to you know, go ahead and show what date you filed your adjustment of status, FedEx receipt. If you paid the filing fees, you know, once the USCIS cashes it, they put a stamp on it when it goes through the mailroom. So when it goes through the mailroom, they actually take the checks and they put a date stamp on it. That may or may not coincide with your receipt notice, but at least that's proof that it was receipted. The other thing I would tell you to do, and this is just in an abundance of caution, if I were you, I would have gone ahead and filed for a change of status to H4. If you haven't done that, now if you're past the 60-day grace period, you know, it's too late, but that's what I would have done. And that way you would have, if you have, then you can, you know, keep a copy of your filing for the H4 change of status as well. If you haven't, you know, there are some instances with this administration where when you are, even though AOS is a stay authorized by the Attorney General, and your attorney can make an argument that you were in an authorized stay because of the grace period when you filed, and because you filed an adjustment, you are again in an authorized period of stay, you just want to make sure it's all documented. So those are the things that I would keep with you in case it's questioned.
All right. This is a question from Prabhu B. I have switched employer in July, but I did not move to new job location and working from wherever I was because of COVID. Suppose if I move to my job location state next year, maybe after H-1B approval, will my employer file amendment again when I move to job location with new H-1B rule? My H-1B transfer received RFE, and my attorney is planning to respond RFE in December. Please advise me whether shall I stay same location till I get my petition decision, or move to a new location before rule comes into effect.
Well, the rule for new wages is already in effect. So if your H-1B transfer reflects the location where you will be working once it's approved, then I would let that process go as is, and that way deal with it in 2021 when we'll know whether this is going to be invalidated or whether they're going to pursue it. So you don't have to move, even though you are eligible through portability, until the H-1 is approved. So I would let it process as is and deal with it upon approval.
All right, next question is from Ram K. What's the suggestion for EB2 PD of June 2011? Downgrade or wait in EB2 only?
You know, we're down to the home stretch right now. So this is probably a conversation you should have had with yourself a little bit earlier than now. It's close enough to this month's, priority date that, at this point, you might as well just wait. The new dates will be out any day now. Or what you can do is you can get the ball rolling to downgrade. Wait to file till next week, but get the ball rolling if that's what you want to do, so you can get the adjustment. Once the visa numbers come out, if it doesn't look like EB2 has advanced, you go ahead and file with the downgrade. If they have advanced, you go ahead and file, you wait till next month to file. Now, the other thing is if you file a new petition versus an amended, you will still have your EB2. So you can also do that. You can file a new petition for the EB2 classification. And that way, EB3 classification, and that way you still have your EB2 because you're not converting it. So those are the two suggestions that I would give you.
Anil Lankipalli is asking, do you have any insight on mailroom rejection for original labor? Did AILW receive any updates from USCIS on this issue?
No, and if you look at the USCIS issued a memo on October 7th that stated that you could file an amend or you could file a new petition when you're downgrading. There were some members that said, hey, we got our petition rejected. And the response that ALS stated was, we heard some murmurings. And if you read it, it's almost as if they're saying, we don't know if this is true or not. And we don't know if the attorneys didn't do what they're supposed to do, and that's why it was rejected. Because typically it doesn't get rejected from the mailroom if you have clearly, stated that you're doing the downgrade and here's the basis for it, and put it in such a way that the mailroom people can recognize that you don't have the original and you're not supposed to.
Okay. Suresh M is asking, my earlier LCA for extension was filed with level 4 wage. With new wage levels, can my LCA be filed at level 3? Is yes, will there be any justification needed to be provided for downgrade?
Yeah, that's going to be a tough question. Where that comes up is in this administration, it would be with the USCIS. I think that's something that they would look for in issuing an RFE, because that was the primary purpose of the wage increase. The other thing is, file it regular instead of premium. And like I said, if the administration changes, the benefit that you would have is it's not under regular processing, it probably will not be adjudicated by January. And so we may have a new president, and then hopefully all of this will be invalidated.
All right. Gopal Arthanari, when is the H-1B rule changes regarding wages and 1 year only extension goes into effect? Would that apply to already submitted but pending with the USCIS petitions as well?
The new wages took effect October 8th, I believe. And the new rules will take, and that's just the wages. So the rules regarding specialty occupation, limited H1 approvals if it's third-party placement, all of that is effective, I think it's December 7th. So as long as you file before December 6th, you would be subject to the new wages, but you would not be subject to the new limitations on third-party placement.
He's following up asking, can I do the interfiling while my downgrade is in process?
It's not a good idea to
Oh,
do
no,
it
sorry,
while
that's not him.
yeah.
Somebody else.
I always suggest that you wait till the underlying petition is approved before you do an interfiling, because it could just be, you know, confusing and a mess. But if you must, you can, but you have to take that risk. And I think we talked about what the risk is in the previous webinar. So I always advise my clients to wait till it's approved.
And that was from KG. That's the name given. Gopal was that person who was asking earlier. His follow-up is AILA applying to challenge that new H-1B rule?
Yes, AILA is, a bunch of organizations are. So both the wage and the new H-1B rules. So they're going to challenge both.
This next anonymous attendee is very eager to go to Canada. Thanks for doing this webinar. My H-1B is approved this year. Can I go to Canada for stamping?
I wouldn't go to Canada right now. Canada they've got a lot of restrictions on travel from the US. You may be able to go to Mexico, and I can share with you at least somebody that has contacted us that is helping people visa process in Mexico if you like.
All right. He actually says, I found this weekly call very helpful. Thank you for conducting this webinar. I've sent few appreciating words to your email, info@chalalawyers testimony. Appreciate all your help to H-1B community.
Well, thank you. And I want to ask, I wanted to reach out, I just haven't had a chance. For those of you who have showed your appreciation via email about these webinars, I'm going to reach out to you again, and I want to know if we can use that in publicizing the webinar. I mean, it's one thing for me to say that people have said that this is helpful, but when I can, take a picture of your email, I mean, your comments, and use that, because a lot of people have voiced that they found this very helpful. It would help us, publicize this. So I hope, I'm going to reach out to you to get your permission. I would never do that without it, but I hope you would let other people know that you found this helpful.
Okay. Yeah, thank you, Mr. or Miss or Mrs. Anonymous. Appreciate it. Please encourage 3 other people to do the same if they're satisfied with us, so we can get some more stars. Thank you. Gaurav Singla is asking, hi, Chala. I'm not sure if this is discussed previously. I want to know how the change in the definition of the specialty occupation will impact my current extension application. My application was filed last week. I've VTech in electronics, communication, working on a software developer application occupation code.
Yeah, so if it's filed last week, it's not going to affect it at all, because those rules don't take effect till December.
Okay. Vaishnavi is back. Follow up. How long does downgrade new Ev3 I140 take? And does AP start right after the receipt or only after the downgrade has occurred?
Okay. These are 2 separate things. The I-140 will be processed, before the October numbers came out, they were taking about 7 to 8 months. With this new insurgence in files, I would think it's going to take even longer. So that's going to take some time to process. All right. The adjustment application is, the AP is AP and EAD is a benefit from your adjustment application. You will have to go through biometrics. And once you get the biometrics done, then they will issue advanced parole in EAD.
Okay. Next question is, this is J. If I downgrade EB2, EB3, not amendment, do we need to file a new LC again and amend H1 before or after new Ev3 I140 approval?
Yeah, they're two separate things. So the fact that you're downgrading, whether you do it via amendment, via new petition, has no effect on your H-1B. Green cards are prospective employment, not current employment.
Okay. And I think he's got follow-up, a secondary question asking, let's see where he is. Yeah. Also hearing that if we file 485 in EB3 downgrade, one cannot apply or use EB2 as 485 is already applied. Is this correct?
Not if you file under new petition. If you file under amended, you could amend back, once it's approved. But if you file a new petition, then your EB2 is still remains. You're not converting as you do with an amendment. You're filing a new, so you're just filing another petition. So if you file a new petition, then your EB2 is still there.
All right. Our friend Abir is back. He says, Shekhar, I had to jump on a call. Sorry, did you guys answer this question, which is a weight change in the EB1 application exhibit, yeah. I believe. You said no, right?
No, don't worry about it, Abir. You don't have to. There's a great deal of flexibility with multinational managers. And so, you can even be paid by the foreign entity. So they understand that executives sometimes, there's some executives that don't even take wages as they're growing the business, but they'll just, so you don't have to worry about that.
All right. Aman is asking, my wife applied for H4 and EAD renewal and is still waiting. In the meantime, she got her H-1B case approved. Is it illegal to retain both H-1B and H-4 EAD? Does she need to do something about it?
Yeah, it's the last action rule. If she filed for an H-1B pursuant to a change of status, whatever the last action that's been taken would be the one that prevails. So if she's gotten her H-1B approved, I would withdraw the H-4 EAD.
Okay, anonymous attendee here is asking, does your law firm help with N400 interview for my mom in Texas?
Yes, we represent N400s across the United States, so yes.
All right. Srinath Thiru is asking, need to ask about 485, and that's about all, but I may probably manage into his.
And Shekhar, today our Q&A is only for 1 hour.
Right, so I was going to say that, we'll have to cut off, guys, at about 1 o'clock, your attorney direction, and she'll explain why. So that if we have not answered a question by 1 o'clock, we've got the questions and we will answer. But if your question was not answered, I think the best thing is to send an email to info@shalalaw.com so that we can respond to that. I may have the questions with me, but I don't have the email IDs and all that. So if we are not able to get your question by 1 o'clock, please send an email to us.
Right.
Thank you. Sandeep Kancharla, how long it takes to get an EAD and AP after you get 485?
Okay, so as I was saying, so the process, how it works is they're concurrently filed. The I-140 is processing on its track. The I-485 is processing on its track. Even if your filing is not current and you're filing pursuant to the dates of filing, let's say the number's retrogress, they'll still process your AP and EAD. They will only do that after you go through the biometrics. So that's taking, I would say about 5 months to get your AP and EAD pursuant to an adjustment filing.
All right, Aman, whose wife had a H-1B and an H-4 EAD approved, and he wanted to know what they should do, is asking, My minor son is in the US on H4. His passport expired and we got it renewed. Do we need to do something about to update his I-94?
No, as long as he's in valid status, next time you file for an extension, you would just use the new passport.
Anonymous attendees ask, can H-1B amendment override the date on I-94?
Yes, because you're issued, when you amend, you get an I-94 card two ways. An I-94 card is the most important status document that you have. You get it when you enter the United States through the CBP. It's issued electronically. I tell people within, once you enter and you can get to a computer, print that out because you want to make sure it's accurate, because it's issued electronically. You're not seeing it right then and there. And sometimes there are mistakes. Another way in which you can get an I-94 is an adjudication through the USCIS, either through an extension, amendment, change of employer. So when they approve your petition, there is the approval notice. On the bottom of the approval notice is your I-94 card. So that is the new I-94 card, and pursuant to the last action rule, which is an immigration rule, last action rule, the last action that's taken on your immigration case would be the new I-94 amended petition, and so that would prevail.
Here is a next question, interesting question from an anonymous attendee. Any idea why visa bulletin is getting delayed so much? What changes do you see if Vice President Biden comes into power? In general, Democrats always fight for illegal immigrants than legal immigrants. At least in Trump era, who have employment dates have moved to give some benefit to backlogged community.
No, he has not. That is incorrect. The only reason why these numbers have jumped is not because he's benefiting. He does not care about immigrants, legal or illegal. Is that he has had the presidential ban, so a number of family-based and other types of, and certain types of employment-based haven't been able to process. That's the only reason why these numbers jumped. And for your kind information, when Boehner was the Speaker of the House, the Senate passed a comprehensive immigration bill, including wiping out backlogs, making it easier for H-1Bs, and Boehner, who was a Republican, did not allow that to be voted upon. He didn't even allow the vote. Senate approved it. Boehner didn't allow the vote, much like what Mitch McConnell is doing right now. That's a crazy mechanism. I mean, it's a democratic society, so we should allow our representatives to be able to vote on the bills that are put forth. So with Biden in office, it's going to be a lot of common sense type immigration, like what, the artificial caps that we have on H-1Bs. There's a big push to remove the backlogs, and they're going to do that by a combination of matters, not counting the dependents against it, and then using the unused numbers from other countries. So I think we can see some very progressive changes within immigration. Not only do we have a Biden in office, but we have to have a Democratic Senate and a Democratic House. And I've talked to all these representatives. I talked to Vice President Biden. I talked to a number of our representatives in the House and Senate. And I think if we can get this craziness and we get a new administration, I think immigration could again be the term that's used for what this country was founded on. It is what the United States is. The first settlers, the pilgrims, they were all immigrants, whether they were, coming here to seek a better life or fleeing persecution. Except for the American Indians and the African Americans, every other immigrant, every other person in the United States came here through immigration. And so I think we will see that greatness flourish again if we have a new administration.
I knew this question is going to get you. Then I wanted to see, because I wanted people out there to hear your views on,
Yeah, I'm very passionate about it. And I give speeches all the time to anti-immigration groups on the economics of immigration. And I talk about, you know, like for every H-1B employee, the company employs 3 US workers. That, you know, the individuals like Abir, who was asked a question earlier, he's investing money into the United States, creating US jobs, you know, paying US taxes. He's actually benefiting the economy. And since 2016, foreign direct investment to the US has declined. Since 2016, F1 students are no longer thinking of the United States as their destination. They create a lot of revenue for the US and create a lot of jobs. So, you know, I tell people, you may not like immigration, you may not even like immigrants. Okay, but if you want the US economy to grow, immigration is the way in which you can grow our GDP.
Ladies and gentlemen out there, if you really want to listen to her after October 31st, when all the filings are over, you can have another Zoom call and she'll talk about it. Tell you now. Went through her immigration herself when she was pregnant. 7 months. It was intense.
9 months.
So we can talk about, I mean, yeah. So, but I will take 3 more questions, and I'm going to tell whose questions I'm going to ask so that the others, please send email. So I'll start with Shilpa G and Rahul, and then Srinath, because I missed his. So I'm going to start with Srinath Thiru. I'm filing 485 EB3 with company who sponsored my GC, but I never worked with this company. So when I need to join this company before EAD approval, or can I join later after getting EAD?
Permanent residence is for prospective employment. You're only required to have the intent, the current intent to work for that employer once your green card is approved. If you start working for them once your EAD is approved, then that's more evidence that you will work for them. The other thing I would say is if you're doing any type of downgrade, since you've never worked for the employer, make sure your ability to pay documents are strong.
All right. 2 more questions. The next one is from Shilpa, and the last question will be from Rahul. So rest of you guys and girls, men and women, please send your questions to info@chalalaw.com. and you get an answer very quickly. Shilpa G says, asking, thank you so much for answering my questions. I would like my forms 485, 944, EAD, AP to be reviewed before I send it to my employer, just to make sure the information I'm providing is correct. Please let me know the process.
Email us and our folks will tell you at info@chalalaw.com.
Okay, Rahul V, you get the last slot. Does location change within same MSA and wage level change from level 4 to level 3 require amendment or just extension good enough?
If you are within the same MSA, there's no amendment that's required. You have to post the notice of posting in any new location, but you don't have to file an amended petition.
Okay, so I think that was the last question. We passed 1 o'clock. So thank you all for joining today, and your attorney will close today's session.
Right, and thank you guys. We didn't want to not have the Q&A during this time because we know that a lot of you have got a lot of pressing questions. Email us, join us on Telegram, probably from today's Wednesday, Thursday and Friday. I'm on it on the weekend, so I can answer a lot of questions on Telegram during the weekend. And we'll have this again next week. So good luck to everyone's, I-140, 485 filings, or just 485 filings. I'm sending positive vibes your way. We want everyone to be successful, whether you're working with us or whether you're working with another attorney. Your success is our success. So have a great week.
I want to put a shameful plug for Chala Law offices. If you think we can do your filing, hey, come on in. We'll get it done. Thank you.
Thank you. Thank you for the shameless plug.
Have a good afternoon. Go and vote, or let others Let me know if you need a ride. U.S. citizens have to vote. I don't care who you vote. You need to vote. All right? Take care.
Thank you, guys. See you next week.
Abir, vote. Abir, can Abir vote? ZB1, right?
No, only U.S. citizens can
Only
vote.
citizens.
Only U.S. citizens can vote. So, and please do not vote if you're not a U.S.
Yeah.
citizen.
We don't want any of those issues.
No, don't
No.
vote if you're not a U.S. citizen.
Got to be good citizens.
Yeah.
The
Thank you,
Commonwealth
guys.
of Virginia and the United States. Take
All
care.
right, bye. See you guys
Have a
next
good
week.
lunch, and Royal Challengers Bangalore won today. Thank you all. Bye-bye.